Okay, are you Rosalio Vela?
Yes, ma'am, I am.
And Mr. Vela was previously in court, entered a plea of guilty to cruelty to a non-livestock animal. The agreement was for a cap of 4 years. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
This says, Your
Are there any additions or corrections?
I have one just quick correction, Judge. On his adult felony court history, that Chambers County received 6 months ago, not 6 years. But.
Okay. Okay. Anything else?
No other corrections, Your Honor.
Mr. Kimler, you may proceed.
Well, Your Honor, this case involves a dog, and this at the outset, I don't think that the lives of dogs are something that should be belittled or taken lightly. I've had dogs myself, have them now, love dogs, rescue dogs. So the loss of a dog's life is a serious thing, and it's painful to see one perish in this manner. I know that Mr. Vela, he wants to address the court, but I think that he has no remorse for that. And I'm not going to try to sugarcoat it. It shouldn't have happened. It was, a terrible wreck for the dog. But I don't think that it was necessarily intentional. He wasn't intentionally beating the dog, kicking the dog, or trying to engage in an intentional act of cruelty. I think it doesn't mean it wasn't cruel. The mental state isn't just intentional. So you can act in a way that he did to be criminally responsible. I don't think it's an incident where he, is just beating the dog to death or something to try to see the glass is half full, I suppose. As far as Mr. Vela himself, he's gainfully employed, supports his family. He does have criminal history, of course, aware of that. Of course, looking at the pre-sentence report now, I would just note that it seems to date back to as far as the last case, 2013, on the misdemeanor marijuana, and then 2012 on the felonies. Indeed, speaking with him, I have spoken with him extensively. I think that his experiences while incarcerated really affected him. He doesn't want to go back to prison. So if he is given probation, I'm sure he's going to do everything he can to avoid being removed from back to prison. He learned his lesson. One of those people, I suppose, it takes one time and they get the message to the prison. So is that right, Mr. Vela?
Yes, sir.
Is there anything you want to tell the judge?
The moment since my release in 2018, I maintained a job. My daughters were in CPS custody when I was released due to the mothers not doing things that mothers should do or parents should do. I fought for custody of my 4 daughters. Within a year, gained full custody of them. They've been with me since. And I've been their only sole provider. And I know the circumstances that with dog and everything is unfortunate. I mean, me not being there and me not doing things that I should have done to try to make sure the dog was okay at the time. I mean, I fully regret that. That's all been with us since my release. That was really my daughter's party. We just moved into the apartment, so we wasn't completely settled. I'm not using that for an excuse or anything. I do take full responsibility.
Thank you. Mr. Nichols?
Judge, this is his 6th felony case. Several state jails for theft, burglary, and then the federal smuggling guilt. And I made a cap offer knowing that it limited his exposure, but I think some time is appropriate in this case for what happened to that animal. Essentially died of heat stroke, being left out on a balcony for several days, it sounds like.
I don't disagree with Mr. Nichols, but I also can see, these are tough for me. This is tough for me. These aren't my favorite when it's part of my job, obviously, but all these caps and unagreeds where I get to make these decisions. You do have, obviously, criminal history. It is all somewhat dated, other than that federal issue was 2016.
Judge, I will ask if the court is going to do probation in this case, that part of his conditions involve some form of maybe humane society or something, either to give back to an organization like that, or to
Probably there may be.
they may not. I realize that's been a problem in the past, as I say it.
Yeah, I don't think I can do that. I mean, I can do it. I don't know that they want
Right,
that.
they don't. I think we've dealt with this a few years ago, but
We did.
they don't want that, so I'll take that out.
If there was something, when I read the PSI, I was trying to think of something as well in case.
May I say something? Is there any way that I can maybe donate to the shelter? And then just have a receipt of it, donating to the shelter?
Yeah, I mean, that's something obviously that you're going to have, if I give you probation, you're going to have obviously some financial obligations, but yeah. Okay, here's what I'm going to do. All right, Mr. Vela, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, and at this time, find you guilty of cruelty to a non-livestock animal. I'm going to sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but suspend that and place you on probation for 10 years. So that means I just gave you 10 years in prison, but you can serve that 10 years while you're out on probation. Okay, so because it's probation, that cap of 4 is off the table now. I followed the agreement. I didn't send you to prison. So it's going to be up to you whether or not you stay out of prison. And if you violate your probation, it's no more cap of 4. I just gave you 10. You understand? So it's much more serious. Cap of 4 probably would have been easier if I'd given you 2 years. You go do your time and be out in 9 months. So this is going to give you an opportunity to be there, raise your daughters, do what you're supposed to do. I am going to order a $500 fine. I'm also going to order that you are not allowed to have any pets of any kind, period. Not for your kids, not anything. You're just going to be pet-free household. Understand?
Include fish, reptiles.
Any pet, period. Okay?
No goldfish.
Nothing. Okay? Take care of your kids.
How long does that term last?
I mean, for right now, it lasts as long as the probation. That's just a condition of your probation. If there's some point and you have some special request, you can talk to probation about that. They can send that over, and I'll decide at that time whether or not I want to modify that specific request. It needs to be a specific request for a specific whatever you're thinking. I am going to order that you donate to the Humane Society every month 1 bag of food. Every single month.
What town did you?
I knew you were going to ask that. I mean, a medium bag of food. I'm not talking about this little bag of food. Okay, so yeah, do that and just make sure you give that to probation every month. Okay, so that they know you've done that every month. All right. I don't want it to be a huge financial obligation, but I want it to be something that reminds you and helps other animals all at the same time. Makes sense? So if you do everything you're supposed to on this probation, you've obviously gotten a great opportunity. You'll be able to serve that 10-year sentence while you're out on probation. The other side, like I said, is if you violate any condition of probation, you can be brought back into court and facing that 10-year sentence that I gave you. All right? I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. Give me just a second. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Kimler. If you'll just have a seat here in the courtroom, probation will call you up when she's ready to go over your paperwork. Good luck to you, sir.
Thank you, Your Honor. I like
Thank
that. I like
Good morning. Are you Tiffany English?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion in each case?
She will, Your Honor.
Ms. English, in 18-30705, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation June 10th of 2019 for the offense of assault on a peace officer, a second-degree felony, and that was a 7-year deferred probation. Is that correct?
Yes, ma'am.
And in cause number 19-31722, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation June 10th of 2019 for the state jail felony offense of possession of a controlled substance, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
Hey, Judge, I just want to clarify for the court's knowledge. I spoke with Ms. Cole. That was extended. When I first looked at it, it looked like it was
Okay.
2019, and now it's 25, that it would have been expired, but I confirmed
That it had.
been extended.
Okay, thank you. Each of these cases allege that you violated your probation. Count 1 in each case alleges that you tested positive on a drug patch for tetrahydrocannabinol and cocaine May 8th of 2025. And is that true or not true?
Yes, ma'am.
True or not?
Yeah, sure.
Count 2 in each case alleges that you failed to provide verification of completing a job search. And is that true or not true?
Yes, true.
Count 3 in each case alleges that you are behind in your court-assessed fees. Is that true or not true?
True.
Count 4 in each case alleges that you failed to successfully complete the SafeP program. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 4 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney, you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Ms. English is not competent?
No, Your Honor.
All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true. In cause number 18-30705, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with your plea agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
In cause number 19-31722, also find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
These 2 cases will run concurrently, which means together at the same time. I'm handing you the trial court certifications in each of your cases that shows these were agreements that I followed, so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Yes, ma'am.
Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas.
Yes, ma'am.
Good luck to you, ma'am. You can go back with the bailiff.
Thank you.
Formal reading of the indictment.
He will, Your Honor.
Mr. Reddick, in cause number 25-0050, the state has elected to proceed on count 1 only. It alleges that you committed the state jail felony offense of unauthorized use of a vehicle from October 14th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
No.
And are you pleading guilty because you actually did what they've charged you with?
Yes, no.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with?
If there's one theme tying this entire docket together, it's how judges balance accountability, second chances, and public safety. In one case, the court uses probation as a last-ditch lifeline with strict conditions attached. In another, a probationer's own admissions clear the path to prison. And by the end, a murder plea reminds everyone that some cases leave the courtroom with punishment decided, but the damage is permanent either way. That's the hard truth about felony court. Every case turns on rules and procedure, but the consequences always land in real lives.
Mr. Rojas, and do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Reddick is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You've also been handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. See, Carrington.
No, yeah, just go, sir.
Good morning. Are you Winfred Lamont?
Yes, Your Honor. Good morning.
And we're going on the unauthorized use, but with the priors.
Yes,
It looks like, okay.
Yes, Judge.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Thank you. See, Mr. Lamont, in cause number 231842, you are charged with the state jail felony offense of unauthorized use of a vehicle from July 14th of 2023. The indictment alleges you were previously convicted of burglary of a building, a second-degree felony, February 9th of 1990. After that was final, you were convicted of unauthorized use of a motor vehicle, a third-degree felony, October 31st of 1991, in 2 cases on that same date, making this for punishment purposes a second-degree felony. And how do you plead to that charge?
Yes, Your Honor.
And are those prior convictions true?
Yes, Your Honor.
I have here, and are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And did you plead guilty because you actually did what they've charged you with?
Yes, Your Honor.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with your lawyer?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Lamont is not competent?
No.
All right, Mr. Lamont, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 10 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I will sign a dismissal as part of this agreement in cause number 250234. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with your attorney.
Yes, Your Honor.
Good luck to you, sir.
Look to you also. Have a good day, Purpose.
And thank you. Thank you, sir. Yes, sir. I'm signing that dismissal now. Rejection was 35 years on that manslaughter case. Has there been any other negotiations or offers made?
No, Judge. The state's filed a habitual offender notice, which my understanding would make the defendant 25 and 99.
And we went over that in that plea bargain rejection back then, so that's been quite some time. Mr. Lowenthal, I want to make sure you understand that your case is the number one case to begin with jury selection next Monday afternoon. After today, there won't be any agreements, or unless it's some new information that comes out with your attorney or Mr. Coleman, or something different than what is on the table today. Do you understand? Okay, and so it's the plan, I think, Mr. Coleman, to go forward on 24-1911, the manslaughter case, is that correct?
Yes, Judge.
And then any issues that y'all know of that we need to take up today while we have a few minutes?
There is one issue, Judge, and it's the matter of the certificate of analysis that I filed in this case. The reason why I'm asking for some clarity on this one, or maybe even a ruling, is the lab that performed the toxicology in this case is located out of state. Forgive me, that state escapes me right now, but nevertheless.
Looks like is it New Mexico?
It is. I've got it here.
I'm looking at your
It's actually
certificate.
Pennsylvania.
NMS. Okay, sorry.
There is a lab that is central to the manslaughter case, because the manslaughter case essentially deals with fentanyl. And what I've done is we'd like to get that laboratory analysis in through the certificate of analysis. And if there is a problem, I'd like to know now so that we can start making the efforts or arrangements to get a lab tech from Pennsylvania.
I don't see that there has been, Mr. Reynolds, I don't see that you have filed any objection as required under that statute. Am I missing that, or have you?
I have not.
Okay, so do you anticipate raising any type of issue with regard to that?
Well, it's a Fourth Amendment issue that I'll raise.
Okay. What section is it?
And every time I forget to put it in my motion or in my certificate.
It always, that's okay, I can find it, because there is a requirement, and I've gone through this a few times. Let's see. If you have an objection, that has to be filed. Let's see. $38.41. Oh, I even have it tabbed, and it says certificate of analysis on my tab, so I can find it. All right. So we're today more than 10th. It says the certificate is not admissible if not later than the 10th day before trial begins, the opposing party files a written objection. So we're within that 10 days. So as long as that certificate includes the requirements under Section 3 of 3841, I don't think there would be an objection. I mean, you could make an objection, but I don't anticipate that that would be. Let's do this. Let's see. Why don't you, I don't if it includes those things and it's got that certificate here, and I'm assuming it includes what's required. If you'll take a look at that, y'all get with me if you want to have a motion or an objection to that. It needs to be in writing. I would need that this week. It's still probably outside that realm of the time frame. At least we can take a look at it. But I would anticipate that it would be allowed based on that certificate of analysis and the fact that it was timely filed.
One other thing I want to point out, Judge, is that my understanding of 3841 is that it complies with that with 3841 or substantially complies, is the way it says in the statute.
Well, it says a certificate analysis that complies with this article is admissible. It doesn't say substantially complies.
And I hate to be so definitive relying on my memory, Judge, but I think I've litigated this before, and I think there is a substantial compliance component maybe toward the end of that statute, but I'll find it, and if need be, I'll raise it in reply or response.
A certificate of analysis, Section 5, is sufficient for purposes of this article if it uses the following form or if it otherwise substantially complies with this article. That's the form, kind of talking more about the form. Section 3 is a certificate of analysis under this article must contain the following information. And it's got a list of 7 items.
You touched on the portion I was referencing, that's substantial compliance. My reading of it is that if it substantially complies with the form, which that form purports to comply with the statute, then that gets us there. But we may be splitting hairs unnecessarily right now. I just wanted to point that out.
Name, yeah. Just double check. It's got to have name, statement that the laboratory is accredited, the description of the analyst, education, training, background, statement that the duties, description of the test or procedures conducted, statement that the test or procedures used were reliable, and the results of the analysis. And
Judge, I'm not going to make them bring somebody down from Pennsylvania, but if
it looks like it's got, I mean, it's 35 pages worth of information, so
but
it seems to comply.
well, I know, but if it doesn't, I'm going to object to it. But however, I'm not going to force them to bring it.
Work order, mainly accurate. Yeah, I mean, it appears just on the brief look that I've got that it complies with what's required under 3841. So other than that, then,
Just a couple of things, Judge. I filed a standard garden variety motion to eliminate. I'm not asking the court to go through that, at least at this moment, but I would like to orally amend that motion to eliminate. I'd ask that the defense not be able to get into any evidence about the victim in this case having, quote unquote, been addicted to drugs or having gone to rehab. The state's position is that is wholly irrelevant to whether or not the defendant or the defendant provided fentanyl to the deceased on the day in question.
let's do it this way, if you don't mind, since we've got a few days. If you wouldn't mind doing an actual second motion, And then, Mr. Reynolds, if you'll take a look at that as soon as it gets filed, and then when we come back on Monday, either before we pick the jury, if we think that's going to be something y'all want to talk about to the jury, or after, be prepared to say, I object to numbers 1, 2, 3, 4, or whatever it is, or if you don't have any objection to any of them, then I'll take care of that. But if you'll, I think it would be easier just for me to be able to go down, Mr. Coleman, if you'll do an amended one.
Yes, Judge.
Anything else?
That's all I have, Judge.
Okay, anything that you have that you know of, Mr. Reynolds? And it does look like, okay, so we've already ruled on the motion to quash. Okay, then we'll see you all back. It's the number 1 case, and we will get started Monday at 1. Obviously, y'all know I'll be around, and I'll be in docket that morning. If something comes up that y'all need that would help us go smoother that afternoon, just let me know. Okay, we'll see you back Monday. Morning, sir. Are you Trevor Green? And Mr. Reynolds, will your client waive the formal reading of the indictment?
He will, Judge. Just, excuse me, before we get going, I'd like to point out that the grandmother of the victim is here in the courtroom today, Millie Stoker. She's not only the grandmother, but she's essentially acted as a mother figure for the victim in this case, raising him since he was like 4 days old. 4 days old.
Okay.
And I've discussed the plea agreement with her, and she's in agreement with it.
Thank you for being here, ma'am. All right, so Mr. Green, in cause number 250524, you're charged with the first-degree felony offense of murder from April 28th of 2025, and how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Reynolds?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, States 1.
It's admitted. Is there any evidence that Mr. Green is not competent?
None to my knowledge.
And Mr. Green was charged as an adult, not certified, correct?
He was charged as an adult.
Okay.
Your Honor.
I was just
There's
trying-
no
Yes, he-
certification.
Okay.
He was 17 prior to the alleged.
Okay. All right then, Mr. Green, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of murder. Sentence you in accordance with your agreement to a term of 30 years in the Institutional Division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you